I think the first place to start with GDPR is the scope of its applicability. So it's going to apply to you if you're processing or collecting personal data of EU residents, right? So if you aren't, it's not going to apply to you. However, I would expect that those people doing business with vendors who have EU exposure are going to be increasingly, over the years as this rolls out, being asked to certify GDPR compliance. That's my guess on how this thing will happen. A couple key terms, a data controller, and so these are key terms that you see over and over again in the regs. Data controller is an entity that is collecting personal data. A data processor is an entity that's processing personal data on behalf of a data controller. And then probably the most key term is personal information, and that is what you've got to take care with. I'm going to read the definition because I think it's instructive. It's defined as any information relating to an individual, whether it relates to his or her private, professional, or public life. It can be anything from a name, a home address, a photo, an email address, bank details, posts on social networking websites, medical information, or a computer's IP address. So quite broad. So the first key concept in GDPR is obtaining consent. Right? So you have to obtain consent from a person whose data you're going to use. You need to be able to prove that the consent was given. So I mean, practically, I would figure that you want a click-through or something that requires affirmative consent to the uses that you have to disclose, so that is something that's auditable, right? If you are investigated or audited, you want to be able to show that. So you don't want it passively. You don't want there to be any question about that. Consent can be withdrawn. If you're dealing with children, defined by the regs as people under 16 years old, you need to get the consent of a parent or guardian. You can't condition consent. Or you can't condition access to a service on consent to data usage that's not necessary to perform the service. There are a couple of exceptions to the consent requirement. You can use data if there's legitimate interests at stake for you or a third party to perform a task in the public interest or in public authority. To comply with legal obligations, contractual obligations, to protect the vital interests of a data subject or another person. But for the most part, there's no reason to conduct business without getting explicit consent. And the consent has to extend to the precise manner in which you're going to use the data. So don't leave anything out. Don't leave any, make sure it's like dried turkey. Cut and dry, objective terms as to what you're going to do with the data. There's the concept of notice in the regulations. So there's a whole laundry list of things you have to tell the person about. So the extent of data collection, the legal basis for processing personal data, how long the data is going to be retained. If data is being transferred to a third party outside and/or outside the EU, contact details for the data controller. You have to notify them as to their privacy rights under the GDPR, their right to view their personal data, their right to obtain a copy of the data, the right to erasure of the data under certain circumstances, generally consisting of situations where consent is withdrawn or there's been unlawful processing, and the right to file complaints with the Data Protection Authority. As you might imagine, there's an explicit requirement for maintenance of data records, so that if the EU or any agency of it wants to audit you, you need to have records on the purposes and the processes, purposes, processes, category of processing, as well as the time limits, how long you're processing the data, how long you're retaining the data. Have these records available for inspection if requested. Another key aspect of these regulations is the requirement of you have to appoint a data protection officer. And so that is somebody whose responsibilities are going to include advising personnel on GDPR compliance, monitoring compliance, and serving as the point of contact for the regulatory authorities. If you are a this is interesting and significant, if you're a non-EU-based company and you're involved in what the regulations regard as large-scale, high-risk processing activities, you're going to have a separate person, separate and apart and above your data protection officer who's resident within the EU to be a second point of access and contact with the EU. So tread carefully if you're engaged in large-scale crunching of data. There is the concept in the regulations of data processing activities that the EU regards as posing particular risks to the data of affected persons. It's typically large-scale or sensitive information or data retained for a long time. If you are engaged in these, and as the regulation is fleshed out and rolled out, lists are going to be developed, published lists of the types of activities that are put in this category. For those activities, you're going to have to conduct what are called data protection impact assessments. So that's the assessment is going to has to include a systematic description of the process and its purposes, an assessment of the necessity and the proportionality of the data processing to the purposes of the processing. In other words, is what you're doing make sense in light of what you're trying to do? An assessment of the risks that this activity poses to the data, and then a description of the technical security measures being employed to mitigate those risks. So you have to, if you're going to be doing business in the EU, you got to make sure you're not in that category of high-risk activities, and if you are, you're going to have a documented, auditable assessment analysis. Now, as far as the technical security measures, I'm not a technologist, I'm just a lawyer. There are resources that are set forth in the regulations. There is an agency, ENISA, publishes a report setting forth the required standard of security measures. Some of the key aspects of it, though, the requirement at least use of data, I'm not going to say this right, pseudonymization, one example being encryption, or making the data anonymous. You also have to keep any encryption keys separate from the data, and in the event you've got a third party hosting or doing the processing, you have to retain the keys separately instead of that being in the processor's possession. And then the final concept that bears mention is handling data breaches. When you become aware of it, you have 72 hours to notify affected people of the data breach, unless you believe in good faith that one of the two following conditions is met. Number one, you determine that the breach does not pose a risk to the data or the affected persons, or the data exposed was in fact unintelligible to those people who accessed it. So to keep things moving, I'm going to turn it over to our next speaker.
Thank you, Frank. I think that GDPR represents just the starting line. I mean, we all know it's not the finish line. It's going to evolve and it'll be understood more and more. But let's take a look back of how we got to GDPR. In our office, we've sometimes said it's like martial law for data security. But in a way, GDPR represents the best practices for data security. It's the best set of rules probably out there right now. And why do I say that? Let's take a trip back. Companies didn't really know what they were doing when they were acquiring all this data years ago, even decades ago. They started using it, and all of a sudden you had this opportunity to do things like analytics, and you could share data with others. You didn't just have the data of your organization, but you had commingled data. You had many, many connections. As time went on, we started finding that in the United States there were different state regulations, and those state regulations have now been totaled up to 50. Just a couple of months ago, we had our 50th state, which is Alabama, publish their regulations. But there's no federal cybersecurity law in the United States, and every state has a different opinion of what constitutes PII, personal identifiable information, and what is the timing for notifying when the breach, back to some of the things Frank said. So why does that all tie what the United States has to GDPR? Well, there's a sentiment in Europe that you do have more right to privacy than we do think of in the United States. That's a generally agreed upon concept. Some people here could be raising their hands saying, I want as much privacy as that possible, but not everybody thinks that way. But in Europe, they do have that feeling. So they want to create the EU's GDPR standard. And it's going to evolve. Right now, for an American company, they're looking for you to have best commitment working towards meeting GDPR. I don't think they expect every company to have GDPR compliance right now. They also have said pretty much publicly that they're going to go after big companies to start. As an example, we're going to go after the big companies. But along this historical trail I was laying out for you, there are thousands of companies just in the United States who never actually interact with the customer or the person whose data they have. They're just data companies. That doesn't, not to saying that Amazon's not responsible for data, and it's not saying that Coca-Cola, which has their own employees' data, is responsible for that, and they have client data. I'm just saying there's companies who have loads of information, and it's not even first-party data. They just have it. And when you have that, in general, you have less commitment to security. Okay, that's a fact, and that's been kind of researched and understood. So what the EU is trying to say is that if you're going to be doing all the things Frank covered, you're going to analyze data, you're going to process data, you're going to find ways to use data in many creative methods. At the end of the day, you better start being responsible for it. It is clear in the United States that if you receive the data from somebody else, you don't transfer the liability. That's an important part because there's a lot of expenses around this. You don't transfer the liability to some other party who's your third party if you're using a processor. Let's use an example. I go online and I buy something from an online vendor on a Saturday. I give them my credit card number, and this could be used in many examples, don't just think credit cards. And I give them my credit card number. It never was held by the actual retailer who I bought maybe socks from. It's all done a pass-through. There's a token sent to the bank. It gets sent back, says there's a good credit card number, the balance is okay. And all the retailer had was just my ship-to address, where I live, proof that I have a good purchase here, and they're going to send me an email saying, here's what you ordered, it'll be delivered on this day. So people often think, well, that's good. The retailer's thinking, that's good. I don't actually have any credit card liability. That's not the case. If the processor's breached, and they are being breached, and there's hundreds of them, if they're breached, that retailer is responsible for all the notifications, okay? And that's what the law is trying to say, is that you don't transfer liability. So you constantly are facing enormous costs, legal, notifications, public relations issues, other things that come about because you actually have data and you've used somebody else to do something or you shared it. Back to this scenario now where there's thousands of companies whose whole business is just to use data. Think of that Cambridge Analytics, okay? And think of what happened with Facebook. It's almost perfect timing that Facebook had their moment in the sun in front of the leadership in Washington, D.C. who didn't really understand the technology in the first place. But they had the moment in the sun just when GDPR was coming to become legally effective. So there are loads and loads and loads of costs and liabilities you have when you have data. I feel like GDPR has gone a little bit too broad in terms of defining what PII is. They've included almost everything. In the United States, you could have an aggressive state like California or Connecticut, New York, which define many things in PII. We use the analogy sometimes when we're in conversations. Everybody here would agree that their brain is more valuable and their heart's more valuable than their fingernail. That's true. We all would want to keep our brain to stay alive and our heart, but our fingernail is still part of our person. And each of these states across the United States has a varying level, a threshold, a description of what is PII. The EU has gone very deep, and as Frank was going into, and there's even more examples, there's many things that are included. So now you really have to have a stranglehold on what you're doing. But the unfortunate part is, most businesses, and this is what all the surveys show, do not know what data they have. They don't know where the data is stored. They don't know who else's data they have. They have a fundamental knowledge of where their bank statement is, and they know where their payroll is. That's not the data we're talking about. They have data from previous employees from 20 years ago. They have data from partners that they've shared intellectual property with. They just have data, and in many places they feel like if data is being ignored, it's almost invisible and it's taken care of. That just is a sitting duck. And the EU is now saying, start understanding what you have, start understanding how you're using it, start understanding what you need to do to protect it. You need to have a data privacy officer. We have something slightly similar in the United States by New York State. And if you think about New York State, it's the most important financial capital of the United States. They have something called the New York State Department of Financial Services Regulations, cybersecurity regulations. And that came out almost 1 year and 1 month before GDPR came out. And they're saying a lot of the same things. You're going to have a de facto Chief Information Security Officer, same as Data Privacy Officer. You need to have compliance with this and that. You need to be doing encryption if it's appropriate, on and on and on. And they're saying if you don't do it, we'll fine you. So a big takeaway that I want to leave everybody with, and we can cover more of this in Q&A, is that you never transfer liability when you have information that's yours or somebody else's. If you gave it to me, if he gave it to me, and I give it to somebody else to do some work with it, whatever it may be, that liability does not bounce to them. It stays with me. And people don't understand that. So you often want to do the following: remove as much of the data as you don't need anymore, and understand that you've competently destroyed data. You want to destroy data. You don't need to hold data forever. And ignoring data because you're busy doing something else is just letting you sit there with a bigger problem. One of the fun things we do in our office is, just for levity, we always find interesting cartoons about cybersecurity. And cybercrime is booming. It's an incredible problem. It's getting worse. There's no one solution to it. It's a human problem. It's a technological problem. It's a process and policies and procedures problem. It's GRC, governance, regulation, compliance. It's all these different issues combined. It's probably the most fascinating area of business, in my opinion. But these cartoons we share are kind of summed up sometimes in one of my favorite ones, which is this couple who's at the window of a bank teller, and they're holding the gun up, and the teller's passing the money, and the teller's almost exasperated and says to them, you know, you could have done this online. And this is really true, okay? And we actually have maybe 20 or 30 of these cartoons, which we use for fun. But what I'm getting at is that you want to start doing everything you can, not because the GDPR said to do it, okay? Not because the EU says to do it, and people debate, well, am I an EU member and all that. The word they use is, are you I think it's called a participant. I wrote that down. It's called, are you the term they used is, are you, let's see here, there's a term they used, are you established? If you are even marketing towards a EU company in the EU, you're marketing towards European citizens, you have not put a human being in that office, you don't have any presence there, and you don't even put it in their language, but you actually are marketing to them, you fall under GDPR. So almost any business of a certain size in any industry could fall under GDPR. And if you have that, let's start backing up and saying, what are the rules here we have in the United States which are around data security and privacy, and build around that, because sooner or later, whether it's the EU, which is going to fine, or it's going to be some other entity in the United States. It could be something, if you're dealing with HIPAA information, with that, you could have state laws. Sooner or later, you're going to get snagged, and it's bad public publicity. It costs a lot of money. It takes years to clean up. And here's an unfortunate thing, but if you're a small business, and small business doesn't mean 3 people. In the United States, you could have 3,000 or 4,000 employees. You're a small business. That's a tiny business still. You are 60% nowadays who've had a significant data breach are out of business within 6 months. The costs of that enormous. So I want to leave you with the thought that start finding ways to be compliant, because it's in the best interest of your business, it's the best interest of your client's business, and you will have more trust and more ability to move forward by doing this. Don't fight things like the GDPR. Embrace them, even if they're complicated. Learn, talk to an expert, get expertise, but don't fight them, because it's in your best interest. It makes your business more resilient. So we'll turn it over to Josh now.
Cool. All right. So my approach to this is I own an agency in Philadelphia, and I am a tagging specialist, which basically means I go onto websites and find the data that people want to get from their site and deliver it into a vessel like Google Analytics or a CRM to allow them to market smarter, you know. And when GDPR first started, you know, the buzzword started to come out, I started getting emails. How does this affect me? How does this affect me? How does this, you know, how does this change the way we're doing things? We're not an EU, you know, company, you know, but one of the first things that we had to deal with is, yes, you are not an EU company, but many of the tools that you use are on a global scale. Google, Facebook, MailChimp, these huge companies that you are using for, collecting data that do need to comply to these standards. So you probably started getting the rest of the panels have said, all these emails saying, we're changing things. And Google Analytics for a while had a PII compliance in place. And you were not allowed to send in any personal identifiable information. And, if that was that, no names, emails, or anything, you can get, regular data. But the problem is that a lot of people don't realize that they are sending in this data just by having a website. And pretty much everything on your website or a website is trackable. And oftentimes what happens is forms that you have on your website actually pass through variables that go into the URL, and the URLs themselves go into Google Analytics, right? So what does that mean? It basically means that somebody, a person that you expect to fill out a form goes and fills out that form, and then they pass that information through in a URL, and then that URL now is in Google Analytics, and therefore you have personal identifiable information in Google Analytics, right? And what is the issue now? Well, before you could, they could take away that entire Google Analytics view, right? But now you can actually get in further trouble for that. So it's important when going through this to understand where to look if anybody does have Google Analytics, or if you are sending in information to your from your website to your analytics, you want to just make sure to put in filters that automatically filter out certain data, and that is making sure that you have a filter that filters out email addresses in page URLs, and to, in general, every so often look in your page, the data set, the page data set, and just make sure that it's all data that you're allowed to have in there, and scrub it if not. Now, the one thing that they changed, Google Analytics specifically changed, when GDPR rolled out officially, is if you guys logged in, you would have seen you must comply to this new data retention plan. And what they were doing is saying, we are going to scrub event and user data from all customer reports after a certain amount of time, right? After 14 months or 24 months. And that was going to be an automatic thing that, would roll out, and an ongoing thing. So, and if it's checked at 24 years, 24 months, you would still have that in your aggregated data in your main Google Analytics, but you wouldn't be able to access any of that data in custom reports. And the reason they're doing this is because they want to make sure that they are complying, and other tools that you are using are going to get more and more forceful in how you use them. So for instance, MailChimp, while Google Analytics allows you, most likely you are not going to have too much user information on your customers in Google Analytics because they forbid it. You in MailChimp or another email service, you have all of their information about who they are, and you can do things similarly where you can really track any level of clicks, and then once that person clicks, you can follow that pathway all the way throughout the site and see exactly what one person is doing. This is going to get more and more, besides ethically, an issue, but also lawfully an issue. So it's important to make sure that people are consenting. You can do this by making sure that you have opt-ins and tags on your website that automatically check if somebody has opted out via their browser to make sure that you're not tracking somebody who does not want to be tracked. And I believe that, over time, these tools will get more and more accessible. Right now, there's in the digital marketing world, there's a lot of like, should we, shouldn't we, should we, shouldn't we? Does it affect me, does it not affect me? But a lot of it is because the tools out there to allow people to do this easily aren't there yet. So, as it becomes more and more regulated, the tools will get easier and easier. But one of them is make sure you have a privacy policy, make sure that you have a cookie policy, and make sure that you're asking people to opt in if you're going to be using their data for different tasks. Yep, that's mine.
All right. Does everybody need to stretch a little bit? I know that was a lot. All right, well, thank you, all of you, for shedding some light on a very confusing topic. Does anyone have any questions right out of that?
Yeah. You mentioned obtain consent, and that you must prove that consent is given, be able to prove that. Can you name some of the means other than, what you just mentioned, the tagging option, where a small business person, a small nonprofit, or maybe a hobbyist, just, wants a list of local enthusiasts, would be able to do that right now to comply?
Go ahead.
Yep. Just from a tool standpoint, if you are using email services like MailChimp or Constant Contact, they now have tools within them that you can build forms that automatically have those opt-in to, opt into our mailing list, a double click, so that allows they are now going for GDPR compliance. So you can use those in a much easier way if you're using those type of services.
And if you're not, and you are using a large platform, I don't want to name it, but I'm using a large platform, an international platform, not based in the U.S., by the way, where I have deliberately, I'm not collecting any type of information on anyone. I do use their contact form, which doesn't require you to even put in your email address. But that platform does acknowledge that it is, using various analytic tools, what they call to process the information, to be able to deliver, your feedback to me via my website's contact sheet, or feedback sheet. So is there any, in other words, to me, all the liability in terms of, what could possibly go wrong rightfully and duly belongs with the platform, because I'm not gaining, I'm not collecting, I'm not processing any information, for the most part from users from the site. So where's my liability?
If you used another tool to provide a service that goes back to your organization, and that actually is a way that somebody else got the information, could be misused, it was just aggregated someplace else, I would say that you actually are, you chose what tool to use. You're using a tool which is, the data might not even be stored in the United States. Now, some companies are saying we need to pull our data back into servers in the United States, not because we don't believe in storing elsewhere, but because that way is another control point if you're dealing, for instance, with people who are part of the European Union. So I would argue that, not knowing your specific case, because you didn't say who you're using, you didn't say what exactly they do, but I would say you actually could be tied to a GDPR issue because you are using a processor or some other service that's helping you do something, and you have access to an EU citizen or the data of an EU citizen, even though you aren't the conduit. So I think you actually would have some liability. The good news is that the EU has a board that runs this, but it's really state specific. It's the member states have their own regulators. For example, in Spain, this is a real fact, not just a story. They didn't really fund it. They actually said, we're not going to fund it. We want to actually have hungry regulators who will go out and go issue fines, and they'll make enough money that they'll actually be able to fund their operations. They gave them seed money, okay? They really did. They gave them seed money, but they actually didn't say, here, you're fully funded. It's not like some government department where you have a full budget, and whether you got the job done or not, you had the full budget. They're saying, be out there and do that. Other states are saying, we're going to go out there and we'll give you some money. The big point is, they're not going to be able to track and follow every, assuming your business is not a global businessman, it's a small business you mentioned, that they're not going to be able to go after they're going to, I believe, when we talk to some people who are knowledgeable in the space, really knowledgeable, who are like with global companies, they say that they're going to go after the big organizations first to prove that they actually have teeth. They show that they can get in the news, because your business would not really be in the news if something happened with the EU, but it would be in the news if they went after a big company who's in the Fortune 500 or bigger or smaller, and then that company got in trouble. That gets people's attention. So I think that you do have a potential liability there, but you're going to be likely, I'm not speaking for them, off their radar because you're somebody who they could get to later on. And this is something which is going to grow as time goes on, because right now the regulators are figuring out what they're going after and what are the high priority issues. Dave, were you going to say something?
All right.
Go.
That's the question. You're talking about the smaller business, but I know that, with all the rights that the subject has, the right to be forgotten, the right to have, make sure the information is correct. How is that going to be with smaller businesses? I mean, because I know if you're too small, you really don't have to have a representative in the EU. But how is that person, how is that going to work for a person in the EU that has maybe information on someone's database here? How would they go about, exercising their rights? Has that been really?
So you're saying I'm an EU citizen, let's put myself, I'll be in Belgium.
Right.
I have data on American citizens.
She's a small business here, or
Right.
a medium-sized business. She pulled data from my data, and now I want to be forgotten. Because right now she has my data, she's already used it for what she wants to use it for. I don't want to use it for anything else.
Right.
And I'm saying, I want it forgotten, or I want it rectified. How would I contact her? Because she's not in the EU, and really, because she's a smaller business, because in the EU, you have to, on a certain side, you have to have representatives over the EU. So how would that work for something like that? Have they figured that out?
That's a good question. I'll actually let Frank give a
Yeah.
response, and I have a thought about it, but I want to hear his legal thought first, then I'll come to you with what I think structurally might happen.
Yeah, I mean, they only have jurisdiction over the EU, so practically, they're not going to show up on our shores, going to a U.S. court. Now, if her business was bigger, such that it had to register and do business and was maybe even paying taxes or whatever, they'd have some regulatory teeth. Maybe a company that had assets over there, or people who could be fined or could be, I know in the States, the FTC was and is the entity that enforces good data security practices by way of enforcement actions and fines and injunctions and things like that under the Unfair and Deceptive Trade Practices Act. That's how they did it. Even though there's no federal data protection law, they went after companies who said, yeah, we keep your data safe, and they didn't. And they said, well, that's a deceptive practice. So I think in her case, they'd have, she's not within their jurisdiction. So it would be very unlikely, even a generation from now, if it's literally just a small home business or something, and maybe there's one or two residents that happen to be in the EU, I just think it's impractical
If I were
to,
an EU citizen, then I would be out of luck.
most likely.
I kind of agree with that, but also want to say that the point about the Federal Trade Commission, they actually have an alignment with the regulatory board. It's called the GDPR regulatory board. They actually have an alignment where the FTC is actually aligned with them to talk about how you can verify that you are self-assessing that you're compliant. And so you can actually say that I've done these things. Now, you have to do them and say you're going to do them, but then you can actually claim that you're compliant under GDPR. But you've not been audited. You're just saying that you've done the right things. Well, it's kind of that, yep. And then also that is partially, the Federal Trade Commission has always been favorable towards the NIST standard. I think most people here have probably heard the NIST standard, the National Institute of Standards and Technology, and they built one of the most useful frameworks. There's one for big business with the NIST standards, and there's a smaller one, which is, we'll call it NIST Light for smaller businesses, and that's something that you could read about. I believe you're following those NIST, as much as you can, the NIST standards, and you're working to be as data secure as possible. I agree with Frank that you wouldn't probably have a problem because you're going to be a small one off the radar, but the trouble would be is if you actually had some bigger company you were marketing for and you got pulled into something. You're small, but you're working at a bigger client, or you're working as a local representative for a big company. Then you could be pulled into that because you're now part of a class action per se in the European Union. But I still think you're going to be off the radar for the most part.
I wanted to also respond to her question about liability and all that. I think you would have liability, if you're using an international platform and that entity did not use GDPR compliant measures, and here's why. They would be defined as, you would be defined as the data controller, right? So that you're the one that's actually eventually using the data, for your business purposes. They would be a data processor, as that term is defined. So they'd be the entity that's processing personal data on behalf of a data controller. So I would think it'd be very likely you would be considered a data controller, even though your small business would not be a data processor. And so you would have liability for the errors and omissions of the data processor that you're using.
Okay, just for the record, they are complying with GDPR as well as NIST.
Okay, good.
And they have servers, another twist, as well as throughout Europe and the Middle East. They have service in the U.S.
One little twist for you. You mentioned how would I find them if I had to reach them, okay? And even
That's what I'm thinking about in terms of, any type of privacy policy statement that I have to make, or term statement, to my users of the website. Right now, I'm just thinking, okay, I don't, I be nice and, courteous and all those kinds of things would probably help with my site. But then I put in, in terms of actual data gathering and processing, they're done by XYZ of this platform. And I put in their terms, their privacy, as well as their address, their main headquarters address.
still think that you're a small business, and so that's a good thing in your favor, and you're doing all you can to be compliant. This is always, like I said in my opening statement, this is the starting line, not the finish line. We're going to learn a lot. We're going to understand what they want. They don't fully know everything they're going to go after, and we don't know their priorities of what their number one findable areas are going to be. They're just going to be figuring out as they go. That's the truth. So you, though, don't, because you're using that other party, do not transfer liability, I don't believe. Because the rules in the United States are pretty clear. I'm not an attorney. Frank's the attorney here. But the rules are pretty clear. If you have data, no matter who you give it to on the back end, your customer doesn't know that. They don't know that. You say, well, I told them on the website, and most people would then argue and say, I never read your website. I don't read all the small print. And that's one of the things they're trying to get away with the EU is these companies would have a unreadable compliance statement. I'm agreeing, and you didn't know what the heck it said, and most attorneys would sit down, and most attorneys who are in that space would say, I don't know what the heck's in this thing. And I've heard attorneys say that, I really didn't know what the heck was in that thing until I read it like 4 times. Now people click, I agree, okay? So, you're saying that they're responsible. It never works that way. The really fundamental thing I would take away for you is you never transfer liability. If you take data, no matter who you use to do whatever you want to do, the laws are saying otherwise. People would always say it's that part, and your processor would say, well, guess what? Are you located here in the Philadelphia area?
Yes.
Okay. Well, all of our customers who are located in Northeast United States, and particularly Pennsylvania, we use another processor, and then they can all point that it was somebody else, and ultimately it goes 5 down the line. So nobody actually was responsible. It goes back to who were started. That's pretty much the fundamental thing. But because you're a small business, you probably can move along and just do your best you can to follow data security standards and always learn best practices. Somebody else?
So we're going to move on to another question, but really quick, everybody just put their hands down. I want to do a survey. Did anyone read any of the privacy policies that you got sent to your email for GDPR? I just want to, all right. Anyone
Yeah,
read
the
more
one for
than
my
3?
platform, I definitely read this.
All right, so to your point, that no one has any idea what's in any of these things, and they're not saying, okay, well, I'll take hands for questions again. Sorry to make that really confusing.
So whose personally identifiable information is covered? Is it an EU citizen? Is it someone who's physically in the EU? If a refugee goes to the EU, is that refugee's personally identifiable data covered?
I think it would
Because
be,
one of the reasons why I didn't bother to read that is I'm not an EU citizen and I'm not in the EU, so it doesn't really matter to me as a person, although it might matter in my job. But if I'm dealing with people's data, how do I know if this is a person whose data I need to worry about?
well, they'd be a resident. So, I mean, you know, if you're a citizen or a resident, that's the set of people over whom the EU has jurisdiction, and that's who they're trying to protect.
So is a
So,
resident someone who's physically present?
No, you could be a college student who came here from Germany. You're going to school at a college in Philadelphia. That college falls under GDPR. So you don't have to be physically in Europe.
Okay. So if your permanent address is in Europe, basically.
if you're a subject of a member state, of a subject or citizen of a member state in the EU,
Right.
that you're.
But if I'm not an EU citizen, but I'm in the EU, like as an American, I could be an expat working in France, would my data be covered under GDPR?
I would expect so. I confess I didn't think about that scenario, but I mean, you commit a crime in the EU, trust me, the cops can arrest you, right?
Right.
So if you're over there,
You should be protected by the laws as
yeah,
well.
yeah.
Okay.
Yes, it's a question related to the earlier one. So as a small business, I was thinking of moving my xyz.wordpress.com to the xyz.com website. Based on what you said, maybe I don't have to rush so fast because the fact that a small business sit on a WordPress website has a slightly more protection because it's under, this bigger company.
Josh, that sounds like one for you.
I think it's more of what data you personally are collecting. If you are collecting obviously there's another thing involved in that, but if you are setting up your website and you own that website and you're personally taking in that information, you are personally responsible for that information, regardless of if it's sitting on HubSpot or WordPress or wherever
It's
it's.
their website though.
It's your website. It's your personal. They're going to information that you are putting on, right? It's like in your name, right?
The website's registered in your name. You're probably paying a fee for the website for hosting whatever you're doing. What makes you think it's their website?
No, this is actually the free platform.
Doesn't matter, but still you're using a tool, free, but you're using a tool to do your business, right? To whatever your function is.
Yeah.
So that would be your website.
It's the same as MailChimp or like we were talking before, Google Analytics. These are free things that you're using of theirs, right? But you are the one collecting that data. You are the one who's using it for a means to get something. They're contacting you. They're not the customers are going onto it. They're contacting you. They're not contacting WordPress. At the end of the day, you're the final funnel. And therefore it's your data that you are collecting, regardless of what platform it's being used.
Relevant to WordPress because it's 30% of the internet. WordPress, the WordPress.org sites have built into them now recently a number of tools that make compliance easier. They do not take away everything you need to do, but for example, there's a utility within there that constructs the basics of a privacy policy, puts in the headings that you need to hit. Some are not going to be relevant to each site, but it kind of outlines a lot of the things that you can then think about, work with a lawyer or an expert, and fill the thing out. But it gets you started. There are lots of plugins that will put a cookie acceptance, compliance, affirmative checkbox on your site. And so that you can, and they even come in the same background colors as your site if you want. And so you can more easily comply with that. There's something that lets you put in an opt-in for, you know, if you have a blog and you allow comments, you're collecting people's data, their email and their name and so forth, and it lets you put a little checkbox there that says, yeah, it's okay for you to collect my information so I can comment, and it won't let them comment if they don't. And there's other tools that will address the other, in addition to privacy and the comment, there's another aspect for compliance with GDPR that in the form of a plugin, these additional, usually free tools. And there's a bunch of them, there's a lot of developers out there. The WordPress community in general took this really seriously and has developed a lot of stuff to help you comply. It doesn't take away your responsibility to actually, you know, dot all the I's and cross all the T's, but it gives you a toolbox that makes it a heck of a lot easier than starting from scratch.
I want to make sure I understood one thing that you said a few minutes ago. GDPR applies to European citizens who aren't necessarily resident in Europe, correct?
Yes.
You could be, like I said, a college student who's from Europe, and you're going to school here, you fall under GDPR.
So then presumably any business doing business with an individual, no matter where they are, is doing business with someone subject to GDPR regs, correct?
Statistically, perhaps. You know, I mean, I don't know how many. You know, EU. I'm sure it's more than a few EU citizens are here for business or whatever.
Especially here.
Yeah.
So then, does any of the tools collect information on citizenship as part of the data collection process, so you know if you want to do business with them or not? Because one of the easy approaches that I read about is simply exclude those who are coming to your site from the wrong geography, from Europe. That doesn't get rid of the problem.
That's correct. They are, a lot of places are blocking, the Europeans are having trouble right now. This is in the news in Europe, that they're having trouble because they can't access many sites right now because it's being blocked for the EU reasons. And I agree, but some American companies are actually saying to the server provider, block communications from European citizens, European geography, okay? But that doesn't solve the problem, as you're saying. The European citizen could be, or member state, could be anywhere in the world. They could be in China right now and communicating with your website from China, but they're still an EU citizen. So this setting up the firewalls geographically, I don't think it's going to be a very good strategy long term.
I read about and was assuming was not, but maybe reasonably effective. It's not 100% by any stretch. Let's put it that way.
This is a somewhat stretched example, but a Dane comes to the United States, rents a car, gets into an accident, takes it to an auto body shop in Langhorne that has this janky 1999 website, and, you know, has to provide, you know, credit card, ID, address, email address, and so forth in the process of getting the fender straightened out. The auto body shop in Langhorne is, you know, dealing with an EU citizen. Is that, I mean, theoretically, does it, not that they're going to go after them, but it's down to that level? Is that what you're saying?
Yeah.
Okay.
That would be subject to the GDPR. Yes.
Have there been any promulgations on encryption keys that make the data unusable to a point where we would be off the hook?
Well, Frank chatted about that before towards the end of his presentation. One of the best things we believe security-wise that any company could do, skip GDPR, just anybody. You don't care if you don't even know anybody in Europe, and you only deal with people who are within 10 miles of your office, okay? And there's no Europeans. You're just dealing with people you probably grew up with, okay? In that case, the best thing you can do, and I reflected on this earlier, is start identifying what information you have. Start knowing what your crown jewels of information are, okay? What are the most valuable things you have? And not only segregate things and have privilege access, and there's 25 things that any security person, there's people in this room who are in the security industry, I know some of them in this room, and they would be able to give you 25, and I can give you 25, do these things. But let's say you can't do everything because it's too much at one time. The thing that would help you the most in this case, sir, would be, along that line, is take the data that's most valuable and separate that from the rest of the data you have, different hosting, whatever it may be, different server, whatever you want to put it on, just separate it. And encrypt it, and then keep the encryption keys separate, so if in case the encryption was, somebody accessed that, they can't get the keys. But on top of that, privilege access is a big thing too, knowing that only you and maybe your CFO, okay, have access to that. Those are things that are fundamental, which will really solve a lot of these problems, because the EU said in Frank's presentation, you have 72 hours to notify. But if the data was anonymized or has been encrypted, you probably can step back and not have to do that. So your best thing you can do for your own good, not even following EU regulations or GDPR, just for your own business to protect it from a breach or data loss or all the things that go with it, is to start picking the most important information, separate it, privilege access, encrypt it, keep the keys separate, and then start cleaning up things you don't need anymore. Get rid of things. And deleting does not mean getting rid of stuff, because it's just usually compressing it someplace on a disk. Get rid of things and start making it the process. Almost like every year you do something personally that you improve yourself with. But yeah, you can say encryption is encryption is generally respected, including the United States, as the most logical safe harbor. When you say, yeah, they got it, but I'm still protected because it was encrypted. And that's a very strong argument if you had to go to court or somebody suing you. But I'm not an attorney, he's the attorney here. Do you agree with that, Frank?
I agree, yeah. I mean, encryption is sort of the gold standard of, it's specifically referenced in the regulations. They want to see the data either anonymized or encrypted, at least one or the other. They want to see that. So that's the gold standard, so I certainly agree.
I have two questions, and I think I can bring them together real quickly. The first question is, some of the examples that you use, particularly as they apply to what we're all agreeing are smaller businesses, U.S. businesses principally, local businesses, they're very helpful because they allow them to see it. The student example, for instance, the rent-a-car example that we used a minute ago. But if I'm like really confident that ours is a domestic business and our actual exposure is rather minimal, or so I believe, is GDPR something that I should be thinking about? Because the standard and the stringency within is coming in our direction. I understand it to be principally a European thing, but is your vision or counsel here, it may look different here, but the notion of that is coming in this direction?
Yeah.
I think so. Yeah.
The Trump administration recently, and that's in their pushing for, because there's not much sentiment in Washington for expanding and having a federal cybersecurity role. We don't have one. There's no federal cybersecurity law of any type. There's not, but there probably will be something. You see, California's been a leader in data security, and California is very aggressive about that. New York State became very aggressive and set the highest bar for now that you could have for financial services. So you're a broker dealer, you actually are an insurance, you're a bank, whatever you may be, okay, trading house, high levels, okay. What's to stop some other state? Colorado came out about a week ago and just said, we're going to actually increase their state level to make it one of the most aggressive in the country. So I feel like it's like a game where one leaps ahead of the next one and go to the next one. Will we have ever have a national cybersecurity law in America? I have no idea. But each state is moving ahead, and you can see strengthening of other rules and regulations. So sticking with best practices, even if it's not EU, and being as secure as you can be as far as following best practices, is only in your best interest, even if a regulator hasn't taken you that far yet.
And then the second question, very briefly, is it's the difference between the protection and housing of the data and, to some extent, the use of the data. And the particular thing I'm curious about is the strength of the opt-out notion. So, for instance, in the case of my work, a lot of the people that I work quite closely with, they kind of don't want to get the marketing materials from me because they already know me, so we have that kind of relationship, but they certainly want to hear from me. And what I'm trying to understand is, how strong is the opt-out? Like, is the opt-out intended to capture that idea of any and all communication? Because I've elected to protect myself in that way and I don't wish to receive those materials versus, but I certainly want to keep up the dialogue that we have going. I've never sort of figured that out as it relates to the...
The regulations say, first of all, when you initially obtain consent, you want that to be detailed, right? If there's 3 things you're going to do with the data, or as a result, they're going to start getting the quarterly, marketing blast or whatever it is. You want to, if it's 10 things, you want them to explicitly consent to all 10 things. I can certainly think of an example where somebody contacts you, I love you to death, but I don't need the quarterly marketing blast. I'm opting out of 4 things, but go ahead with the other 6. I could see a partial opt-out, and under the GDPR, you have to be equipped and able to deal with that, is my read of the regulation.
Yeah, a lot of what was suggested, at least in the beginning, and I'm sure it's going to grow, is multiple opt-in boxes. Opt-in, not opt-out. Opt-in to, we're going to use you're allowing us to use your data for email blasts. You're allowing us to call you every once in a while, and allowing people to kind of choose the direction of content and contact that they're that complies with their blessing, and so obviously a form with 25 different check boxes is not the most aesthetically pleasing, but it is suggested to give them as much as you can, with also being reasonable on how you're displaying it.
It's opt-in under GDPR.
Yeah, you have to get them to opt in.
Opt
So
in.
you want, as a lawyer, if I'm representing somebody, I just, show me something where it's auditable, it's a trail. We have 1,000 customers, and here's the electronic record of the consent for all 1,000.
I actually just I have a thought on your specific question, because I've dealt with the email opt-in a couple of times and opt-out, and it's so generally, if you're communicating within a transaction of doing business, so if you're communicating in a business transaction, like if the customer engages you and you need to engage them back in order to conduct business, generally opt-out doesn't cover that. Their decision to do business with you is in effect an opt-in to receive communication for that transaction of that business. So if they say they're opting out in general, and then they send you a letter and they say, I want a response to my letter. If you choose to respond, they're effectively asking for a response. They're effectively opting into a response. Beyond that, my understanding of opt-out is, if a customer says, well, I want these but not those, and you say, well, hey, I can only do one, all or none, you have the option to say, you can only opt out of everything. And so you don't have to provide granular opt-outs. You can just say there's only one opt-out, but really it comes to, I think that question comes down to how granular how much value is there in you being able to make your opt-outs granular? Is there business value? Do you make more money if you make your opt-outs granular? If the answer is no, just give an overall opt-out. So and that's just from my experience with opt-outs in general.
So earlier in the presentation, you mentioned that the originator of the source of information is the one who holds the liability, right? So if you are collecting a form, for example, then you hold liability, right?
Yeah.
So in that scenario, how do you, or I guess in all scenarios, how would you prevent not the data collector, but the processor themselves from adhering to the GDPR policies accordingly? Because of course you can assume that if it's a big company or whatever, they'll probably do something, but you can't always rely on that, right?
Well, yeah, you would contractually require them to comply. You would ask them to warrant and represent that they are doing so, to indemnify you in the event that they don't and fines are levied against you. That would be the first line. Now, if it's some rinky-dink outfit that doesn't have 2 nickels to rub together, that's what insurance is for, right? But that's how I would go about doing it.
Right. So it would be contractually
Yeah.
obligated via not only between you and your clients, but also clients and your
And optically, it's going to matter to the regulators, right? If they see you bending over backwards and somebody just screwed you, lied to you, you might not avoid fines, but I would expect, based on my experience with regulators in other substantive areas, that you'd be viewed as less culpable, acting less culpably, you know.
Let's take one step beyond the regulators, though. I agree with what Frank said. Vendor management and vendor risk is one of the biggest risks out there. And companies constantly are using other companies to provide services. And if that company drops the ball, then that reflects on you. But even separate from the regulator, if you had a processor or anybody else who's doing work for you, not even credit card, just somebody doing work for you, and they drop the ball, if there's enough data, you actually have to, in the United States even, not even the EU, you need to notify those who are affected. And it's not actually that processor who notifies or that vendor. You need to notify all the first party ones. So if Frank gave it to me, our company says, we don't know how to do everything we need to do here. We need to subcontract somebody else. The subcontractor, the third party, and vendors are a very big risk because they may not be as secure or they may make a mistake. Humans make mistakes. They could be hacked, all those stories you hear about. That puts me, my company, responsible for notifying every Frank along the line. So now he knows that we had the problem. So I can't point and say it was all their fault. I could say that probably, but that's not going to work because I'm the one who has to send the letter and handle notifications. And I might have to, if it's a proper amount of information, provide identity monitoring and all the things you hear about. Those are the kind of things that get expensive. Insurance can pay for that. But those are the kind of things that are very expensive. So because somebody else had the problem, you really make this a priority for everybody. Watch who your vendors are, see if they're cyber mature, what are their standards, ask them questions. The more important the vendor is, the more you want to vet them. Some vendors who delivers flowers to your office for holidays, not a big deal. It's flowers coming in. Somebody who's doing real work for you, that vendor is one of the pillars of your business. So you want to know what they're doing.
Or a point of failure, yeah, potential point of failure.
I mean, we've looked at that, right, in terms of vendor relationship. Roughly about a month ago, Frank, correct me if I'm wrong, a month ago we saw an alert from the SEC that talked about data breach disclosure for public companies. We kind of realized that they were kind of somewhat tying that to SOX. We realized that was the beginning of putting CEOs in jail for data breach because of the SOX compliance that the companies have to undergo. So we kind of looked at it from a vendor standpoint and saying if a vendor holds public company data and they have a breach, then the CEO of the public company may be criminally responsible for that loss.
Funny you mentioned, Bill, SOX. SOX came out in 2002 and it's hardly ever in the news anymore. So everybody doesn't know Sarbanes-Oxley is what we're calling SOX. But you never hear about, it's a good point, you brought a good point. SOX isn't in the news much, but SOX was like an early version, I think, of this. Somebody saying, let's look at accounting rules and everything else, and let's financial rules and figure out what we need to do a good job. So SOX, I think, has become quieter, but I follow.
SOX put the CEOs in jail if they didn't comply.
I know, and that's what they're doing. So that's this same thing, I've said the closest thing to SOX that I see in the United States is the New York State Department of Financial Service cybersecurity regs. So they're saying you need to have you could be a broker dealer, you could be a stockbroker. It doesn't matter what you are. You could be a big bank. You could be JP Morgan, okay? You could be, but you have to designate somebody who's a chief security officer. They could be outsourced. You need to follow these steps. You need to know you'd have control of the data. You have tracking of the data. So, Bill, I think that all this goes back to the safest thing I can say is work with the best vendors you can and understand that you actually ask the vendor for proof of what they're doing. The old trust but verify. Make sure the vendor is doing what they say, because if you can say, here's documentation, the vendor had a problem, I think it's along what Frank was saying, but you actually know that you actually did vet the vendor as much as you're capable of doing. Now you have a problem, you can say, we asked the vendor for proof, and this is what we have, and we believe them to be as secure as possible, as proactive as possible, versus somebody says, I just hired somebody, I heard they're good. That would be a hard argument to win, and I'm not an attorney.
Right. Well, and that's what we say on cybersecurity across the board. Make sure you have a good, solid answer, other than I just didn't know or didn't care, and David just, he was a good guy.
Yeah. You guys want to add anything to his question?
No, I think you hit the nail on the head. I mean, you have to. I would want, if I was a big enough company, what you want to show is due diligence. And what is due diligence varies with the context, but I'd want it to be provable in court. If somebody comes after me, I don't want to have the fact finder guessing, because you can't cross-examine a document, right? So if there's audit records that show you checked and the vendor certified, you got a leg up. Yes, Reed.
If you're in the business of creating websites, Josh's company is, I do, and other people here do. and the website collects information, a contact form, and uses mail service. Do I understand that the owner of the website or the business that's associated with it has the primary untransferable liability for what happens to that data? I might get dragged into it.
Yes.
But they can't really offload, so, oh no, my web developer was a jackass.
Correct.
Yeah.
You are correct.
Good to know.
But no, let's be, right, I'm not an attorney either, but I've been down the road with a lot of attorneys. So my expectation is there's going to be a big debate, right? The company, and go back and forth. The marketer who designed the site is probably going to be in a lot of trouble.
Well, yeah.
Unless they advise their client.
Well, the person, if I'm the ultimate client and I have a website and I have any number of vendors, so I'm the data, I'm the data controller, right? So the buck stops with me. That doesn't insulate them from suit by me. So the vendors, secondary, tertiary vendors, I'll have causes of action. I mean, if something really goes, there's no money damages liability for, an esoteric breach of privacy per se. I mean, that's just not, that's been attempted, but there's no there's no money value to that ephemeral breach of privacy, even though it's very real. But if there's cleanup costs, if there's fines, those are the things that the vendor will be on the hook to me, especially if I have the right contractual arrangements in place.
The thing that I did was I just made all my clients aware that this was happening and to be aware of it and to do their own due diligence and to reach out to a security, a data security lawyer, as I am not one. So just doing my own due diligence of saying that, we built your site, now you're in control of your site, so go make sure that it is, collecting the data in a responsible way.
To follow up on that responsible thought, Josh, we don't see this in our office as being an expense or a hassle. This is actually something that's a business advantage for the web developer. If you're developing more secure websites, nothing's perfect, but more secure websites, that's an advantage.
Right.
You can actually present that to your clients, right?
Right.
If where's the lady there? Ma'am, if you have your local business, okay, you've done everything you possibly can do following proper frameworks. You just make something up. You've done the most you can do. You've actually given yourself an advantage over a competitor who does something, because there's got to be somebody who does something what you do in the world. It's not just one of anything in the world. So you now have an advantage. That vendor, the competitor, could be out of business one day because they had a big mishap. They missed something. They got in trouble with regulators, or they got in trouble because they just got sued because a client got pissed off that they did something wrong with the data. So everybody here can look at this as a positive. We see this as a value added for our business. We see this as something where if we know more than somebody else, we're not perfect. Nothing is secure, 100% secure. Any database or anything can be accessed, whether it's malicious insider, good hacking, human mistakes, whatever it is. Nothing's fully secure. But to be the best you can be, okay, to use the best training, awareness, culture of your business, technologies, everything together, all these things together it makes your business more resilient and more likely to survive when others won't. And you can tell a client, if you get into that conversation, we're doing so many things. Are the other ones who compete against us doing that? No, we're not. They're not. They'll ask them that if they're smart. And you have an advantage. So don't see anything we're saying here as work and a problem. See it as it's actually a value that your business may have that others don't have.
So having the best of anything, I guess, can get pretty expensive. So these big companies don't really have a choice, especially as GDPR is going to hit them kind of earliest. But how can kind of small and medium businesses kind of keep best practice and be compliant with GDPR, but also, I guess, budget more towards that kind of data protection?
Well, I just spoke last. Why don't you guys go? I'll be happy to comment on that, but you guys, I went last.
I mean, yeah, kind of like what we said earlier, which is just making sure that you are using tools that are compliant with GDPR and using and implementing them in a way that you're knowledgeable about what kind of data you're putting into your system. You can do basic research into what types of data are not okay, you know, what PII is and how it should be handled from the different tools that you're using. And I think, you know, like you know, the other panelists were saying, just being more aware and more knowledgeable on the subject yourself will allow you to understand what you can and can't do, so that you are making more educated choices.
I would also say, look, I'm call myself a layman in terms of technology. I'm a lawyer, but it seems to me with the passage of time, so many of these, the security standards and how to comply have become somewhat of a commodity. You know, that it's like so. What is that? The PCI standard. You know, there's tools that have been out there a while and there are many tools, and a lot of them get you to the same place. And so, rather than trying to reinvent the wheel, if it were me, I'd contract with somebody that's got, you know, a track record of good performance, and not try to take that on myself. You know.
Get some help.
Yeah. Yes, sir.
You know, what's been really a big thing, and I don't want to confuse, but I think the biggest thing is we were talking about actually who is eligible to be under the GDPR regulation. I think when I looked at the GDPR, I did read it, and I read all the articles, but it was talking about territorial.
Right.
So, and it was talking about those in the union. That's been something that's been going around, you know, the circles with different, you know, we were talking about what, you know, because you were talking about if you were in college and you were an EU resident, but you were living here,
Right.
and you had data on that person here, while they were living here, then most people are going with that spirit. We're going to go in the spirit of GDPR, but basically they would not apply that particular regulation to them if they're in here.
Right.
As opposed to if they were in, like if you're pulling data from someone who's actually physically in the EU, then you would say, okay, I'm going to have to apply GDPR principles to that. But if they're physically here in the United States or anywhere that's non-EU, then the person or the business would not really have to worry about that. I mean, that's something that's going around.
From a practical standpoint, the EU can't prosecute people or fine people who are resident outside of their territory, okay? That does not alter the intended scope of the GDPR or the intended applicability. You know, so, I mean, the United States, for example, has certain conceptions of the rights its citizens have or should have when they're abroad. However, if you go to North Korea and you take pictures of the wrong thing, you know, like that goes right out the window, and it becomes an international diplomatic incident, but you might not come back alive, right? You know, so that's really when you're, you know, you live in Copenhagen, but you go to school at Penn, or you're born there, and you go to school at Penn, and Joe's Pizza, you know, takes your credit card information and blah, 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 and something bad happens, there's your practical recourse would probably be to enlist the aid of, you know, if there's a state mechanism for enforcement, to go that route, or depending on what the representations were about data security, the FTC, you know, would have jurisdiction over Joe's Pizza in, you know, on the Penn campus.
I made some notes because I thought that question might come up and wrote down exactly what it says GDPR applies to. Okay, if I read some of these points. GDPR applies to organizations established in the EU that process personal data in the context of the activities of that establishment, regardless of where the processing takes place. That's the first one. And the next one was organizations not established in the EU that offer goods and services to EU subjects or monitor their behavior. So that kind of, maybe this lady there. Yeah, I'll read that again. Organizations not established in the EU that offer goods and services to EU subjects or monitor their behavior. Another one is that data controllers not established in the EU, to use Frank's term before, but in a place where member state laws applies to public international law. This one's generally not applicable, but it's a oddball. And it says here how to tell if your business is affected. Property, business, employees, or data in the EU, your organization will be considered established. You are definitely falling under GDPR. Do we offer any goods or services to EU data subjects? A little different than what I said before, same kind of a concept. Do we market to EU customers, refer to them in marketing, refer to them, not even doing business with them yet. We're just referring to them, okay? We're offering that. We can get great things for European citizens, and you haven't sold anything. That still falls under the GDPR.
You're agreeing with people on that one?
On that one.
In EU.
Well, they could be a person who is a EU citizen. I still believe, I don't think this is court tested yet, I'm just going to say. So remember I said this is all the starting line, May 25th, not the finish line. We don't know how it's going to turn out because nobody could envision how a major regulation. Just to finish up though, offer goods or services in EU currency, that's another one that makes you for sure, or allow customers to place orders in a local language. You're definitely falling under EU GDPR. And the last part was, if your organization collects personal data on EU subjects, you will fall under GDPR. This is going back to Josh's stuff. Cookies, geolocation, tracking, anything. You didn't even do any business. You're just keeping information about an EU citizen. That's clearly it. So a lot of these things are great questions. I don't know if we actually know the full answer yet because this is 1 month old and nobody's got they're going to go after the big targets first. I'm sure there'll be some good, they'll want to set an example, but all these questions I think will be answered over time. Does that answer your question, Dave?
We don't have any direct customers in EU, but we use a database vendor that is supported from EU. Depending on the time of the day, if you make a service call, it goes to the European call center first and then gets rerouted to many parts of the world. So how is they have access to the database? So how will that affect us?
So your database contains information relating to EU subjects?
Maybe.
I mean, that's really where the law is grounded. I mean, because I do think it's clear, the example of the person from Copenhagen who's going to school here, I think it's pretty clear that the GDPR, now it might not be capable of enforcement here, but by its terms it applies, to the collection of data here.
And if that company sends consultants here, how do we protect ourselves? We have to keep the data separate.
How do you protect yourself?
Yes, let's say they send consultants here, and we have to put the data in the database for building access and all.
Okay, so I mean, how do you protect yourself? Well, you would follow the consent and notice and technical measures set forth in the GDPR. I mean that's the simplest answer. I mean, to your question.
But they can't enforce anything here, right? Because
Correct.
They don't do any business.
Yeah, they're like if somebody gets really hurt by some problem, and that injury occurs here, you've got local, state, and federal enforcement authorities. And depending on where it happens, because as has been mentioned, it's a patchwork of 50 different state data privacy laws, and you also have the FTC lurking out there, depending on what was done and how it was done. But I mean, if you are an EU subject and you are injured, if that was me, my first thought would not be to call the EU for help. It would be to call, the state attorney general or the FTC. So, if you flip it and you're a business and you're dealing with consultants coming from the EU and you're collecting data, I mean, you should assume. I also agree with the statements that this is the EU, the GDPR is the best codification of what are best practices anyway. So your best protection wherever you're doing business is to comply with the industry standard best practices.
You're preparing yourself for what somebody else, you asked that question, will there be something national? We don't know. I mean, nobody knows. But laws are only going to get more stringent because there's a bigger problem. Cybercrime is increasing. The amount of losses is increasing. Public frustration is increasing. And it's a problem which is a dynamic problem, and it's only churning more and more activity. And there are smarter and smarter people in cybercrime. And just also beyond cybercrime, there are people who just make mistakes. People send the file to the wrong place. There's no crime whatsoever. But that is actually a data breach because some medical record got emailed to the wrong place. Something else somebody's payroll company sends their payroll information, has birth dates and, Brianna's information. That gets sent to the wrong place. That is actually a data breach. Nobody broke in and stole anything. Nobody actually hacked them or it just happened. Those are the bigger numbers are reportable. And that's why you hear in the news sometimes some medical centers being fined because they made a mistake and put information showing in a window of the envelope that showed personal information. They didn't do it intentionally, and nobody intentionally broke in and took it, electronically. So following best practices, like they said, best practices is only in your best interest because it'll make you less likely to have a problem. And if you have a problem, you'll have a better understanding of what happened, how to close it down as quick as possible. You'll have a breach response plan. You'll have an incident response plan. This is not something to kick down the road and say, well, I don't fall under EU, so I'm okay. Following these procedures, following the highest standards you can and keep your business running is only in your best interest because it's likely to keep your business going because it's inevitable for almost any organization that sooner or later you will have a security incident. You will have one, and then how do you respond to that to keep yourself in business? Because when these things happen, we've had clients who've had them. That's all they do. They don't say, well, I have my IT guys taking care of that. Every executive in the company, everybody's working on that. Regulators, notices, talking to lawyers, on and on and on. This is your full-time job. You don't run your business much anymore. And so you may then face costs. You may have all kinds of other things that are happening. You may lose clients. You could have clients who say, you know what, I can get that someplace else. They're having a hard time. Your system can be brought down. You may have weeks or months to get your system brought up if you had a full physical attack on your system, okay? Some kind of very good ransomware or something, okay? Or worse, some better malware. So these are things where you don't want to say, oh, I can sidestep this. I think that do as much as you can because that's making your business stronger for whether the law says you have to be stronger or you want to survive in a dangerous digital world.
Is there any equivalent of IPA in the GDPR?
What's that?
Any equivalent part of the IPA in the GDPR? What covers the IPA part of the medical patient regulation?
I don't know the answer to the question. You mean like basically like HIPAA or something? Like
Yeah,
HIPAA? I don't know. I don't know the answer. There's a European version of HIPAA. If there is, I assume there is, but I don't know what it is. Frank, you have any comments on that?
I don't know the specific European laws on protection of whether they're separate. It would probably be a matter state by state. I would think medical records, but that's a guess. I'm a U.S. attorney, so.
And the UK company they are under GDPR too, or they are separate?
No,
They're not under GDPR.
UK? They were now.
Before Brexit.
Before Brexit they are, but Brexit's coming along. They haven't backed out of Brexit. So I should say, Jerry's right. They are now, but once they're in Brexit, they're out of GDPR.
Depending on how one law is passed, yeah.
Well, they could actually have their own state laws that are very similar to GDPR. But technically, they will not be part of the GDPR regulatory board once Brexit's finished. So I would correct what I said. I should say going forward, they'll be technically out of the EU. Well, they seem like they're still going ahead with it. You had a question? Okay.
Yes.
Data miners and aggregators in the EU who service private security and private investigators. Is there any mention of that in the law?
Not specifically, but they'd certainly be covered. I mean,
I know in the United States we have tracers and some other companies.
Yeah.
PIs use and lawyers use.
Yeah, they're not, at least from my perusal of the thing, they're not separately called out, but they're not exempt from it. There's,
Well, how could you not? Well, if they want to keep, their business is to sell data, so why do they get rid of it?
well, they're subject to the GDPR. I mean, period.
Okay. So they can handle it and sell it, but they have to secure it.
Yeah.
Okay.
Yeah. Everybody handling data has to comply with it.
I just opened up my news and saw Jerry Brown just signed a new online privacy law in California today.
California's been the leader for a lot of things. You think about smoking in buildings, okay, years ago, and pollution. Like it or not, California is often a leader in setting regulations that they believe benefit the public. And California, known in the security community, has some of the very strongest data security regulations right now is a state. Don't forget, it's a state law, and no surprise, but other states are saying, you know what, we can do that too. Until about 4 or 5 months ago, there were 2 states who didn't really have anything, so if you actually had an event there, you would get, you'd be in a quagmire of what to do. That was South Dakota and Alabama. They both passed. But let me give you a little trivia about why that's important, what you just said. With these, just back in America now, this is separate from the EU. If, let's say, I do business and I sell to everybody here, you're all from different states, okay? And you buy whatever my product is or service, and I do business with each of you and you're from different states. You don't have home state law and say, oh, I'm in Pennsylvania, that's where my business is, so I only have to deal with the Pennsylvania laws. The way these things are set up, you have to deal with the law of every single one of your interactions, the customer living there, their state of residence. Every single state, you're dealing with the regulators in all those states, notifications according to all those state laws. So that's something which is very complicated and very costly. So very important that you understand that. You don't have home state comfort and say, oh, I only have to deal with Harrisburg and I'm okay. Every single person here could also be from another state, and every time you do business with somebody from another state, wherever that's their home state, that's their residence state, you are now falling to the laws of that state too, and all these state laws are completely different. No symmetry, no consistency, nothing. You could never even have a possibility of figuring out what they say. That's why you get into specialty lawyers. You're getting into potentially specialty investigators, forensics, on and on and on. So that's why I think that, again, being as knowledgeable and as enthusiastic as you can be to have the highest standards only benefits you because you want to reduce the problems. You'll never get rid of your problems, but you can reduce the complexity of your problems if you take steps now.
On that point, if you were compliant, or you'd be well compliant with the GDPR, would you be compliant with, or at least as compliant as the 50 states, even California, require you to be? Would you be? Is there any state that's more stringent than GDPR?
I don't think so. I think that's the most stringent regs in the world right now.
Yeah.
But Frank, you're your attorney.
I'd agree with that assessment.
So I feel like, Reed, in the whole planet, the most stringent, most complicated, we pulled everything in. I said earlier before when I was giving my little opening presentation what our thoughts were. I said I felt like this was the most complete one in the world. Maybe they went too far, and I used an analogy which I didn't finish. I talked about my heart and my brain not more valuable than my fingernail. Okay, I certainly would give up my finger before I lose my heart, because I want to stay alive as long as I'm meant to be here. So what I meant by that was some states have said, we only really care about your most important information, your heart and your brain. So we care about your birth date, your social security number. Some other states have said, oh, we also care about your email address. How personal is your email address? Some states think it's not a personal issue. Other states say that is an issue. Your email address is part of your identity. Oh, I have a second phone number, not your cell number. Some states count that, okay? There's a lot of things that are different in every state. The EU has bundled almost everything you can think of. Almost anything you could think of is covered under the EU data privacy laws. So I do think that's the most stringent. Frank, you're agreeing, and Josh, you're agreeing? Yeah. Mm-hmm. And I use that analogy was that my heart is my social security number, my brain, my birth date. This is my fingernail, which can grow back, and that is an email address. But some places, including some United States states, see that's part of your identity, and that counts as a notifiable event if there's enough of them lost.
So the benefit would be, if you're compliant with GDPR, you've got the states covered. No state is going to be able to.
You've set a very high standard for yourself, which would be the best you can do for your business to be resilient and to know that you're going to be able to withstand whatever comes along.
I realize this is speculation. Do you see the business community, I mean, the heaviest businesses, calling for a uniform federal code, which you said doesn't exist and it doesn't look like there's any immediate possibility of that? But I would think that they would want to say, look, I can't deal with South Dakota, North Dakota, Mississippi, and so forth. Give me one law. I mean, and we all applied that. And, then would, I mean, you would think that they would be.
I think that's the point of the California thing, right? If you have a state saying that you have that 27 million of your potential customers have to comply with this law, that's as effective as a state, as a national law.
Large corporations are begging Congress to pass a federal standard, but Congress won't.
Yeah. Well, do you have a comment, Frank? Because you're in the legal field.
Comment about what specifically?
His question, do you think that, one was, do we think that if you follow GDPR, you're meeting most of the state regulation, then kind of filter out a little bit, what would happen if, somebody asked, could we actually see maybe a federal,
Yeah, I mean, that's been hanging out there for a while. I just don't, I don't see it as a subject of congressional interest right now.
I
mean,
agree with that.
It's dumb. It's dumb as a bag of hammers not to have one, but that's not the only thing now, is there?
That California just passed 1 in 4 people, and there are 90 million people. So 1 in 4 in this country, chances of doing business.
They don't have 1 in 4. They have about 50 million people, and there's about 320 million people in the country that we know of.
It's a 1 in 7.
Yeah. That's different than 1 in 4, though.
Yeah, right. But California, if you have a national business, you want to do business in California. It's the biggest market, so
Yeah.
you'd be nuts not to be focused on what they're requiring.
It's 39 million.
39 million, okay.
That was 27, that's a lot.
I thought it was 50, so, okay.
So would it be possible, are there any business entities that you could say with reasonable confidence to which the GDPR does not comply? And I don't mean they'll get to them down the road. I mean, these guys basically.
I have an
Don't
example.
collect or process data.
I
it doesn't apply to you.
have an example that people ask me, because we often get in conversation regarding insurance and who's responsible for what and liabilities, and I do use an example. It's a real example. You're a local barber shop, okay, and you don't take any credit cards, and people can show up. You don't have a database. You literally have people show up. Gentleman wants a haircut. It could be ladies too, but just gentleman, man. So I'll use that example. Gentleman shows up, sir. Can you cut my hair? Cut your hair. You give him whatever the price is. You give him a tip. You say thank you. He has no online presence, no database, never collected anything. That person doesn't really have any kind of digital security risks at all. Almost everybody else has employee records, okay, that are digitized.